The whole purpose of a grand jury is a check on government abuse.
The assumption is built in that the prosecutor is going to be ethical.
The long-awaited mega motion is here, in which the defense seeks to have the case against Turtle Boy Aidan Kearney dismissed. How and why did they think that prosecutors screwed up and presented unconstitutional materials? I'm Andrew Myers. This is About the Law. Joining me is California attorney Yolie Medina. Hey, Yolie, how are you?
I'm fine, thank you. How are you?
I'm pretty good. We had a lot of reading to do this week as the mega motion to dismiss the Aidan Kearney Turtle Boy case came out, and the documents are lengthy and they're detailed. Before we jump into them, as we're going to do, what were your initial impressions?
The legal issues are pretty clear as to what the motion is wanting to do. In other words,
yeah, before we dig into the whole motion, why don't we just give our viewers a framework? There are two central issues. Issue number one is, should Aidan Turtle Boy Kearney's grand jury indictment be dismissed on grounds that the integrity of the grand jury was impaired by an unfair and misleading presentation?
And the second point is that whether the indictments should be dismissed due to the Commonwealth's failure to properly disclose specifically requested exculpatory and automatically discoverable evidence.
So before we actually jump into the motion itself, our viewers, now that we know what the two issues are, our viewers should really know what the law is. What are the rules of law that control these two questions? And the first rule of law is that if the Commonwealth knowingly uses false testimony to procure an indictment, or where there is a reckless disregard for the truth that leads to the admission of false or reckless evidence, the indictment must be dismissed.
The other part of the law that is at issue here is it's axiomatic that due process entitles a criminal defendant to the disclosure of all favorable or exculpatory evidence in the possession, custody, or control of the prosecution. And this includes impeachment evidence or other evidence that may impair the credibility of a prosecution witness.
Okay, so now that we know the issues and now that we know the controlling law, we are going to dig into the facts that are applied in this motion. But before we do that, attorney Mark Bederow, speaking about a different case, the case in which the prosecution is trying to indict Karen Reed with regard to witness intimidation, he made some comments about what a grand jury should be all about.
The whole purpose of a grand jury is to even though grand juries indict everyone except, Karen and Aidan the first time, right, is a check on government abuse. In other words, we're not going to just let the government say, we're charging you with a crime. You're going to have to get a grand jury of citizens to say, well, there's at least probable cause, and we're not even going to make the judge be there. We're not going to let the defendant be there. The defense attorney won't be there. There's no argument. We're going to make it real simple, but it's still a form of check, okay?
So, a grand jury is there to kind of, make sure the prosecutors don't really get out of control as they seem to be in this case. I have to thank Mike Crawford of the Young Jurks. He did this interview just before this motion we're looking at dropped, and he was trying to get Mr. Bederow to talk about it. Bederow didn't want to, but he made some really good general comments that really do apply. So without any further ado, let's take a look at the motion itself. Now, this is the memorandum of law in support of the motion. That's where the meat of any motion is in the memo to support the motion. So Here is how they couched the applicable law. An indictment must be dismissed where the integrity of the grand jury proceeding has been impaired by an unfair and misleading presentation. And that's a 1984 Massachusetts case. If the Commonwealth knowingly uses false testimony to procure an indictment, the integrity of the grand jury proceeding has been impaired, and the indictment must, not could be or might be, must be dismissed. A prosecutor's reckless disregard for the truth that leads to the admission of false or deceptive evidence may also warrant dismissal of an indictment.
The facts which established that the Commonwealth impaired the integrity of the grand jury are straightforward. The critical issue for the grand jury's determination was whether Aidan Kearney intended to intimidate witnesses. But rather than let the grand jury, the exclusive judge of the facts, resolve the key issues through its evaluation of accurate and truthful evidence, Special Prosecutor Kenneth Bello intentionally misled the grand jury with false and misleading testimony and evidence that introduced evidence of uncharged crimes to smear Mr. Kearney and increase the likelihood that he would be indicted.
As an initial matter, Mr. Mello and Massachusetts State Police Detective Lieutenant Brian Tully, and we're going to see those initials, MSP for Mass State Police and DL for Detective Lieutenant Tully, didn't mince words, making it clear to the grand jury that they expected an indictment. Both expressly stated their belief that Mr. Kearney intimidated witnesses.
Mr. Mello bolstered his and D.L. Tully's improper opinions of Mr. Kearney's guilt by intentionally and repeatedly eliciting false and misleading testimony from D.L. Tully. 28 separate times Mr. Mello and D.L. Tully misled the grand jury by giving a false impression that Mr. Kearney's video episodes were admissions of his alleged witness intimidation.
Specifically, Mr. Mello elicited patently false testimony from Tully, which inaccurately suggested to the grand jury that Mr. Kearney's innocuously named hours-long episodes in which he discussed numerous topics unrelated to his interactions with witnesses in the Karen Read case were little more than brief statements about his interactions and or commentary about the witnesses, which he named in a manner evincing his intent to intimidate witnesses. And we're going to take more of a look at that in a little bit. Mr. Mello and Tully knew prior to the grand jury proceeding that none of this was true.
What the grand jury didn't know was that the exhibits introduced by Mr. Mello and described by D.L. Tully and Mr. Kearney's episodes were in fact edits of Mr. Kearney's actual episodes created by D.L. Tully at the behest of Catherine Peter, an quote-unquote enemy of Mr. Kearney, whose atrocious credibility included at least 2 instances in 2020 and 2023 where she literally manufactured and forged evidence to harm him.
Now, Catherine Peter, who we're going to see referred to a lot later on, even as Peter, she's a former employee of Mr. Kearney, and they parted company on very bad terms, and she's kind of made it a life mission of hers to do whatever she can to throw roadblocks in front of Mr. Kearney. She's even falsified. She took a piece of federal litigation that had nothing to do with the case, and she twisted it around and edited it to make it look like it was a federal case that had been filed against Aidan Kearney, and it was a total fraud. She made it up. She took the word processor out, and it was just a total fraud. And that's speaking objectively. Following Ms. Peters' guidance, Tully clipped what she flagged as relevant portions of Mr. Kearney's episodes, renamed his edits so they sounded as though Mr. Kearney created them to emphasize his purported intent to intimidate witnesses, and placed most of them in an intent folder he created. In other words, Tully created a folder containing edited clips of what Ms. Peter believed constituted evidence of Mr. Kearney's intent to intimidate witnesses. These edited and nefariously renamed videos depicting Ms. Peters and Tully's biased opinions were the exhibits presented to the grand jury ostensibly as Mr. Kearney's episode and as proof of his intent to intimidate witnesses. Let me show you that. That's on a different document. Let me show you that. This is what was shown to the grand jury. This is actually what the grand jury saw. The actual names of the actual episodes are all the way over on the right. Mr. Kearney's actual episode title. All the way on the left, you see the titles that Tully changed it into. So, for example, let's take a look at this one here, number 5. This is what they showed the grand jury. They told the grand jury that Aidan Kearney had done an episode entitled Episode 595, Can Kick Colin Albert's Ass. Well, that wasn't the title that Kearney gave to his own episode. Go all the way across. And the actual title of the episode was Kendra Lara Crash, Interview Paul O'Keefe and Carl Dougal Defend Canton Murderers. So that's the actual name, and they phonied it to make it look like he had some kind of an intent, to kick Mr. Albert's butt. So, and this goes on and on. They took all these clips.
Easily verifiable, right? I mean, it's easily verifiable, right? I mean,
yeah, 25 of them. I've got pictures of you, 25, and that was not the title. The actual title was Episode 598, Breaking Karen Reed Defense Files Motion to Recuse Judge Cannoni and Oppose Gag Order. So they take the actual, episodes, which are quite lengthy, 2 hours and 26 minutes. They shorten it down to 29 seconds, and they pretend that, they gave a title of No Right to Live Peacefully, or I've got pictures of you. So, it was intentional and it was fraudulent, and they showed false evidence to the grand jury. That's all there is to it. So now we get back to the motion. There is irrefutable evidence that Mr. Mello and Tully knew they repeatedly misled the grand jury by concealing their collaboration with Ms. Peter before Detective Lieutenant Tully sliced and diced Mr. Kearney's episodes into out-of-context exhibits to support their view of his intent. And we just showed you that.
Mm-hmm. Nevertheless, Mr. Mello and Tully relied upon Ms. Peters' guidance to assemble evidence for the grand jury. For no discernible purpose other than to mislead the grand jury, Tully edited and renamed these episodes and then misleadingly told the grand jury they came from a folder of Mr. Kearney's episodes named Intent.
Yeah, and so a point I really want to emphasize right now, and that is that Mark Bederow, who's believed to be the primary author, although Tim Bradle is also co-counsel in the case, Mark Bederow is constrained from making direct statements about this case. But again, right before this motion was posted, he did say this about the Norfolk County District Attorney's Office. And again, I thank Mike Crawford for allowing us to use this.
If the DA's office, which has an obligation to serve the public, right, and to bring forth ethical and proper and just prosecutions, is abusing the grand jury system and abusing and exploiting the criminal law to help people that they sympathize with in a civil proceeding, then they should all be fired today, tomorrow, yesterday, and face additional penalties. I don't want to believe that's true. It's an interesting theory. I'm not going to say that it is true, but it couldn't be more inappropriate for the district attorney's office to allow itself to be exploited by civilians to further their interest. Having said that, you might read a little bit more about that too in the next few days.
Okay, so that's the only reference to this case in that clip. Again, he was talking about that other case in which the special prosecutor, Robert Cosgrove, has filed a motion saying he does want to get into Karen Reed's phone and take a look at what's in there with the possibility of prosecuting her for witness intimidation. So his comments, although going to the other case, are certainly relevant to this case, I would say. Getting back to the motion, the circumstances here are worse than another case they compared this to, where a few weeks ago, just a few weeks before this motion dropped, the court dismissed an indictment for multiple counts of inappropriate conduct because the prosecution misled the grand jury about the full context of the defendant's statements. The court dismissed those indictments, holding that the prosecutor intentionally misled the grand jury by attempting to conceal the full context of the defendant's statements by hiding it in plain sight. Interesting analogy.
Yeah, Mr. Mello's conduct was far more egregious than the deception that required dismissal of the indictment in Blakeney. Mr. Mello and Tully didn't just hide the ball like the prosecutor in Blakeney did. They distorted the actual evidence and then destroyed the ball. Mr. Mello introduced only cherry-picked, out-of-context statements from edits of Mr. Kearney's actual episodes, which ensured it was impossible for the grand jury to consider the accurate context of Mr. Kearney's full statements and his episodes, even if it desired to do so.
Okay, and so then we go to this section that says, short of literally instructing the grand jury that as a matter of law it must find that Mr. Kearney intended to intimidate witnesses, a line Mr. Mello approached with his unsworn testimony, it is hard to fathom a more compelling example of how a prosecutor's misconduct impaired the integrity of a grand jury proceeding on the critical issue for the grand jury's determination that Mr. Mello did regarding Mr. Kearney's alleged intent to intimidate witnesses.
But Mr. Mello engaged in additional misconduct to make sure he secured Mr. Kearney's indictment for witness intimidation. He dedicated the entire first day of the grand jury proceeding to a topic that had nothing to do with witness intimidation, smearing Mr. Kearney with irrelevant and prejudicial allegations of uncharged, quote-unquote, bad acts. Mr. Mello examined 3 witnesses, introduced an unauthenticated and unreliable recording provided to Tully by Miss Peter, and bolstered Stephen Scanlon's irrelevant testimony by having Sergeant Yolie Medina regurgitate Mr. Scanlon's testimony by reading into evidence the full context of his hearsay interview with him, all for the purposes of making the grand jury aware of an uncharged wiretapping allegation against Mr. Kearney.
Couple of things about that. Don't you love the use of the verbs regurgitate? I mean, they could have just said Buchanan reading Mr. Scanlon's testimony, but no, he regurgitated his testimony. And then doesn't that taint a grand jury where you're talking about charges that were never brought, allegations that never even came forward in a court of law, and they're making them aware of an uncharged wiretapping allegation? Really?
That is weird. That is so weird. It's just so, it's like a movie. I don't know.
This is a clear abuse of the grand jury system, I would say. And, we've had commenters over the months, if not years, not only in this case, but in other cases, like the Koberger case, just pointing out that the use of grand juries can be really an abuse, where prosecutors are unethical, where prosecutors bend the rules, where prosecutors actually throw the rule books out the window. It reminds me of, the old days when if they wanted to nail someone, they just bring them in and say whatever they wanted. And I don't know. It's close to that.
Yeah.
Maybe I'm just regurgitating my thoughts, but standing alone, Mr. Mello's obvious intent to smear Mr. Kearney through the introduction of uncharged bad acts was flagrant misconduct that impaired the integrity of the grand jury proceeding and compels dismissal. And if you go back to the law that we read up at the top of this episode, where there are flagrant misconduct episodes that impair the integrity of the grand jury proceeding, it must. And that's the language of the rule. Not that it could or it might or the court can find. No, it must dismiss the case. So I don't know what Judge Doolin will do with this, but this is going to be before him. And within 7 days after a motion like this is filed, the court clerks need to set a date. So, and then under the Massachusetts rules, the prosecution has up until 1 day before the actual hearing is scheduled to file their objections. So, who knows when this will be scheduled? There is a hearing on an unrelated issue coming up, but this will not be heard at that point. So that's the first point that we mentioned up top. That's the issue of whether the grand jury indictment should be dismissed for misconduct before the grand jury. But then now we move into point 2, and that's the issue that you raised, and that is, were there discovery abuses? Did the Commonwealth fail to come forward with appropriate discovery? And the answer is pretty clearly yes.
It's axiomatic that due process entitles a criminal defendant to disclosure of all favorable or exculpatory evidence in the possession, custody, or control of the prosecution. And that's the Brady case. This includes impeachment evidence or other evidence that may impair the credibility of a prosecution witness, and that's the Giglio case.
Two big major cases in defense. And so what we're talking about is, did the Commonwealth violate its discovery obligations? And to me, it's fairly certain. When a prosecutor is uncertain whether evidence may or may not be favorable to the defense, the prosecutor must err on the side of caution and disclose it. And that is based on 2 Massachusetts cases from 2024 and 2022.
Okay, so since Mr. Kearney's 2023 indictment, the Commonwealth has exhibited breathtaking indifference to its constitutional and statutory obligations to disclose evidence to the defense. This has included Mr. Mello's patently false representations about the state of discoverable evidence and his failure to comply with a court order to complete discovery by May 8th, 2024.
Yeah, remember that date, May 8th of 2024. And so, I'm sorry, go ahead. What were you going to say? I apologize.
That's a long time. May 8th, 2024.
So 18 months after the court-ordered deadline, the Commonwealth still hasn't satisfied the Brady and Rule 14 obligations. And for those of you outside of Massachusetts and the legal world, Rule 14 is the Massachusetts Rule of Criminal Procedure that talks about discovery, both automatic when a case is first brought, the prosecution must turn materials over, certain materials, and also if there is Brady or Giglio material, which Yolie talked about before, that's also got to be turned over automatically. But there's more. In this case, the defense actually requested information that, the Commonwealth was just kind of, whatever, which is not a good way to look at a case. So since 2023, numerous of its agents have had actual possession of undisclosed favorable and discoverable evidence, including but not limited to Robert Cosgrove, Mr. Mello, Detective Lieutenant Tully, Sergeant Buchanan, Lieutenant John Fanning, and other members of the Massachusetts State Police, and ADA Adam Lally.
So in addition to demands for discovery on February 23rd and March 19th, 2024, the defense made 3 extraordinarily specific and well-sourced demands for discovery: Brady material and Giglio material prior to the March 1st, 2025 amendment of Rule 14. And then it cites the exhibits where they're found.
And we've talked about some of that before, actually. The Commonwealth's response to these demands for discovery of September 12th October 8th and October 17th, 2024, pretty much a year ago from now, was to shrug its shoulders, even though the demands couldn't have been more specific as to the information being sought, including exculpatory and discoverable material related to Ms. Peter, Tully, Buchanan, and Ms. McCabe.
So on October 8, 2024, on a 15-page demand outlining what the defense knew about the bizarre relationship between Ms. Peter, Mr. Mello, and the Massachusetts State Police, the defense detailed extensive concerns about the Commonwealth's failure to disclose any evidence about Ms. Peter under Brady Giglio and Rule 14. The demand referred to Ms. Peter's direct role in the prosecution against Mr. Kearney, documented her shocking admissions that she spoke to Mr. Mello on, and then it's redacted, of her contacts with him that she spoke to Mr. Mello, and there's quotes, redacted, and explained why her communications were discoverable and favorable to the defense.
You got to wonder when the defense, I guess they're under certain constraints not to disclose certain information, but when they have to react, you got to wonder what those conversations were all about. They've got to be good.
Yeah.
Although the Commonwealth externally ignored these specific demands, internally, Cosgrove and Mello were acutely aware of the significance of these demands. On December 16th of 2024, Mello forwarded some of his email communications with Ms. Peter and Tully to Cosgrove. So they're doing some internal stuff here. They're not letting anybody know, but internally they're going, uh-oh. These emails were entirely favorable to Mr. Kearney. They confirmed that Ms. Peter worked directly with Mr. Mello and Tully. They confirmed that Ms. Peter frequently sought input from Mr. Mello and that he assigned tasks to her, including just 2 days before the grand jury proceeding. Let's stop here. What's going on here? A known adversary of Aidan Kearney, someone that doesn't like him. They had an employer-employee relationship, something that went rotten. I don't know what it was. There are allegations that maybe she fooled around with the money. I don't know. The fact is that the two of them parted company some time ago, and now she's working at the behest of the assistant district attorneys and the Massachusetts State Police because, they don't like Kearney. They want to get Kearney. That's been stated pretty affirmatively before. But who's telling who what to do? I mean, is she on the payroll? Or is she just telling them what to do and then they're giving her assignments? I mean, that is, I have to say, that's an inappropriate relationship.
Bias much?
And to then, have this person that dislikes, the defendant, have that person working directly with the district attorney, that comes pretty close to the comments that Mark Bederow made in that previous cut that we played.
Yep. Yet the Commonwealth failed to disclose these favorable communications, which conclusively prove the prominent role Ms. Peter played in the grand jury investigation until July 7, 2025, which was more than 6 months after Mr. Mello provided them to Mr. Cosgrove.
So they're sitting on it.
Yeah, the emails didn't include access to the links Ms. Peter sent to Mr. Mello and Tully.
Interesting. Mr. Kearney's defense has suffered irremediable harm due to... So discovery disputes are never anything that a court likes to deal with. They'll just say, well, if you got it eventually, or, if it was just a mistake, no big deal. You've got to prove harm, and that's what they're saying here. Kearney's defense has, in fact, suffered irremediable harm due to the Commonwealth's unjustifiable failure to disclose favorable evidence, which, combined with Ms. Peter's apparent deletion of exculpatory and discoverable evidence in the Commonwealth's actual possession since September and October of 2023, has left the defense without an opportunity to acquire important evidence that favors Mr. Kearney's defense. At a minimum, the prosecution knew, or should have known, in 2023 that much of the still undisclosed and now destroyed evidence was favorable Giglio material because it undermined Ms. Peters' credibility. Well, of course she's going to try and edit that out improperly, but she's going to do it anyhow. It demonstrated her bias against Kearney and supported the defense's theory that shoddy, bad faith investigation relied upon a civilian who despised Kearney and had a documented history of falsifying evidence against him.
God, this is just crazy. It's crazy.
It's beyond belief. It's just beyond belief. We're getting close to the end, folks. Bear with us. We're close to the end.
So the court can't ignore the fact that throughout this matter, Mr. Mello and Tully have engaged in pervasive misconduct, which included the intentional presentation of false and misleading testimony to the grand jury. Nor can it be ignored that Mr. Mello violated a court order instructing him to complete discovery by May 8, 2024, or that on July 10, 2024, the Commonwealth assured the court and defense that it recognized its obligation to provide exculpatory evidence.
Wait a minute. Hold on. Back up the bus. Didn't they just say that some of these materials were in the possession of, I think it was Tully and Mello way back in 2023? 2023, they had material. They knew that there was a court deadline of May 8th of 2024. Gives them plenty of time, but they still, and then they state a mistruth. I'll say it that way, but you know what I'm really saying. On July 10th of 2024, the Commonwealth assured the court, oh, we're good. We recognize our obligation to provide exculpatory evidence. Yet it took 16 months and too many to count discovery demands for the Commonwealth to sheepishly. I love the writing of this. I love the writing, using words like regurgitated and sheepishly. So anyhow, 16 months later, and too many to count discovery demands for the Commonwealth to sheepishly admit that undisclosed and discoverable evidence in their actual possession was lost or destroyed by Ms. Peter. And they still, why aren't they wiping into her phone instead of going into Karen Reed's phone? 2 years after they got it, they couldn't get her the first time, so they want to try again. Why aren't they going into her phone or computer or laptop or whatever? I mean, oh, I lost it. Yeah, right. The dog ate my homework too. They still haven't disclosed all the discovery in their possession, custody, or control. All of this could have been prevented or explained more than a year ago if the prosecution simply honored its duty of inquiry and investigated, spoke to Detective Lieutenant Tully and others, and complied with their obligation to make themselves aware of discoverable evidence and to disclose it. But, we know that they don't do that from when Adam Lally was on the stand in the Miles King case. Proctor had sent out 6 subpoenas, years ago. And he only turned over the material from one and some of the material from another. So 4.5 subpoena returns were never turned over to Adam Lally. And Adam Lally was asked on the stand in that case, well, what's your policy for following up? Oh, well, we don't really have a policy. We do. That was his answer. That's my take on what his answer was. Whatever. Whatever.
Yeah. So the Commonwealth's years-long indifference to its constitutional and statutory rights to disclose evidence to Mr. Kearney warrants a finding that its non-disclosure and loss of evidence was egregious, deliberate, and intentional. Accordingly, the court should presume that Mr. Kearney was prejudiced, strive to create a climate of adverse to repetition of that misconduct that would not otherwise exist, and dismiss the indictments, or at a minimum, order an evidentiary hearing to determine whether the Commonwealth and its agents intentionally suppressed or delayed disclosure or caused the loss or destruction of specifically demanded exculpatory and discoverable evidence.
I don't know what I think about this. I really don't know what I think about this because, in a way, I have 2 thoughts. The first one is in a way that gives the court an out to not dismiss the case. Oh, well, you yourself said that, we can have a hearing, and so I'm not going to dismiss it. We'll have these hearings. But on the other hand, those hearings are going to put people like Mello, the initial special prosecutor on the stand. Those hearings are also very likely going to put Tully on the stand, Buchanan on the stand, and that's not going to go quickly, I wouldn't think. That could take time. So I don't know. I guess what are your thoughts on that?
I mean, I think the court could order an evidentiary hearing regardless of whether it's in the motion or not, regardless of whether he's requesting it or not, right? I mean,
I guess, sure.
So I don't see the harm in it, but these people are going to testify and it's not going to be an easy process if they do have that evidentiary hearing.
I'm hesitating to state the thought I'm having now, so calm me down, please. But why have an evidentiary hearing when we know that these officers are get on the stand? And I'm not going to use the L word, but I am going to say they're going to get on the stand and give whatever version of the facts they think they can get away with giving. So is it really going to be probative to put them on the stand from my viewpoint? Am I too much of a skeptic to say that?
Well, no, I don't think you're too much of a skeptic. I just think that it makes this thing very complicated when in fact everything the judge needs is in the paperwork and it's easily verifiable. So to have a hearing on it, yeah, it might make things more complicated. And maybe you're right. Maybe it shouldn't be. Because everything is there. I mean, you see that the titles were changed. You see there's actual exhibits to this motion that show you exactly what is going on. So, I mean, I can see it, and I'm not even totally familiar with the Kearney case, but in learning, I mean, I can see it. I can see what's going on.
Oh, I think you know enough. I mean, it's true that there are layers and layers and layers and layers. The initial charges were brought against Mr. Kearney way back in October of 2023. And then he was wrongfully, incarcerated in December of 2023 for 60 days. And so, there are a lot of deep layers. There are a lot of deep layers to this case, and it has a long history. And it would seem that a judge might, at this point, seeing how dirty the whole case is, just, motion to dismiss. Good, get this off my desk, but, hold my beer. Who knows? Who knows? So that's the essence. Again, we don't do episodes that go on for hours. And as I said at the beginning of this episode, my hat is off to those who have the time, effort, and ability to go on and on and on about these things. And I highly recommend that you go and take a look. Mike Crawford of the Young Jurks was nice enough to let us use some clips, and we do have one more. Before I play that, Yolie, do you have any closing thoughts about the motion that we just read?
No, I think it was a very well-written motion, for sure.
Yeah, they've been working on it for some time, and they've talked about it's coming, and
It was good. It was a good motion.
And Bederow was asked, he can't comment directly about, the meat of the case. There are constraints and guardrails, as they talk about, against saying a whole lot. But he was asked, and he did answer what really went into the lengthy preparation to do a solid motion like this.
I'm speaking generally now, okay? I'm not talking about the merits. There are different ways to do things. Having seen a lot of the normal practice of how motions are filed in Massachusetts, what I can simply tell you is that stylistically, this has a lot more New York feel to it than the way generally it's done in Massachusetts. In other words, in New York, motions are generally made by affidavit, sworn statements, actually alleging facts, sourcing said facts, explaining where those sources come from, providing copies of sources, and then filing a second document, which is a legal brief, what lawyers call a memorandum of law, briefing what the legal issues are and referring to the factual statements and evidence in the affidavit. That's how this will be done.
And that's how it was done. And in fact, what we just read was actually the memorandum of law. It is I believe, a 36-page document.
33, I think.
Yeah. And it does go into quite a bit of detail. What it does is it takes the fact, 35 pages. What it does is it takes the facts, which, were developed in an affidavit, which was 66 pages, and it takes those facts and it applies the law and cites the law. And we saw that throughout, Brady, Giglio, and some Massachusetts cases that pertain to Rule 14 discovery obligations. Also, we saw some law in the memorandum of law with respect to grand juries. Grand juries are secret. And they're held, behind closed doors. And that's why they have that saying, I'm getting to hate it, but, there's that saying, you could indict a ham sandwich. And this is why, even though they were unable to indict Karen Reed and Aidan Kearney when they tried the first time back in March of 2023, when they tried to indict the two of them for conspiracy and intimidating witnesses back then, they were unable to do it then. And that's why they're trying to do it now. But the whole grand jury procedure is rife with potential for ethical problems, for potential of abuse, for potential for prosecutors to do what is alleged in the motion we just read and, skew the evidence. And in this case, work with somebody that had a bias against the defendant. And, I don't know. It just, remember go ahead. Go ahead, your turn.
The grand jury, the way the grand jury works, it assumes it's built in the assumption is built in that the prosecutor is going to be ethical. That when they do this, they're going to be ethical and they're not going to try to get in information they know they shouldn't or try to skew the facts so that they can get the indictment. And a lot of times, when you find out later, and it's very hard to get the grand jury transcripts. I mean, you find out later, oh, this is what they did. Oh, this is what they did. And it's just kind of like, you lose faith in it because when you really find out what's going on, it's crazy.
Yeah, I guess grand juries are, in fact, used in many states. The better procedure, if the people behind the scenes in the legal system really want the public to have trust and faith and to see transparently inside of the system, would be a preliminary hearing. As in, remember the Koberger case, there was to be a preliminary hearing and they were trying to get Bethany Funk up to Idaho to testify, and then the prosecution, in my opinion, really tainting the public's perception of the whole handling of the case, went behind everybody's back and indicted Koberger on 5 counts in a grand jury proceeding. So even though there was to be a preliminary hearing, and I believe, if I remember correctly, that was going to be streamed, they went behind everybody's back. Nobody knew about it until the indictments came out. And it's just, as attorneys, we're supposed to understand that. As attorneys, we're supposed to respect that. As attorneys, we're supposed to say, well, the mechanisms of the law are not always, as, the public would want them to be. We're smarter than them. But no. It seems like people should really take a close look at it. But I have little faith that will happen in Massachusetts. They do review rules regularly. That Rule 14 discovery obligations was, in fact, revised right in the middle of the Karen Reed case, and that became an issue. They broadened the duties of prosecutors to look further into the existence of potential exculpatory information. So rules change. Rules change all the time. We used to get new rule books all the time and have to pay for them every year, but now, thank God, it's online.
It's online, yeah.
It's online, but, I'm looking at some rule books on my shelf that, we had to buy them every year. But my point is that it's a slippery slope, and I think this case demonstrates that they slid all the way down to the bottom.
It's just I can't. It's like a movie. It's like some kind of. I could see it turning into a movie.
Now, we did not do viewer comments this week. I was a little bit busy, but we've been getting some great viewer comments, and we will continue with all these ancillary cases to the Karen Reed case because, you know, our commenters are saying, stay on it. Keep watching that case. Keep watching the Kearney case. Keep watching the Brian Walsh case, which is scheduled for trial on October 24th. But I don't know if it'll go to trial because they're outstanding matters. A appeal came down from the single justice of the Massachusetts Supreme Judicial Court saying, nope, the trial court was correct in allowing all of those searches, which are extremely incriminatory, to allow all those searches in. Remember, you and I actually read the initial decision.
Bored everybody to death.
Well, I don't know. I wasn't bored, but it did go. It went longer than I thought it should have gone. But so that case, you know, when people are telling us stay on it, stay on it, stay on it, and I'm going to stay on it for two reasons. One, because people told us to stay on it, but it is fascinating. Just I, you know, have been practicing law in Massachusetts for decades, longer than I really want to admit, and it's just that these cases are just some of the craziest cases I've ever seen. They really are. I mean, I can think of some other crazy cases, you know, including Mr. Brennan's defense of Whitey Bulger, the whole Bulger experience going way back to the 90s and 80s was just a head scratcher in Massachusetts. I don't know, maybe we should do a standing green episode on Whitey Bulger. Do you think anybody would watch that?
Well, it involves Hank Brennan, so.
And there have been so many movies. There have been movies and books, and one of my clients brought me in a book that I didn't even know existed. So there's been so much. Let us know down in the comments. Should we do a evergreen episode, even briefly, on Whitey and Whitey's trial, Whitey's flight from justice for, I think it was 16 years, when he was hiding right in plain sight? So I don't know. Those are my closing thoughts. You have any closing thoughts?
No, I'm fine. I think we covered it as best as we could.
We always at the end come up with an emoji, and I'm just trying to think. Do you have any ideas for an emoji? If people have watched this all the way to the very end, do you have any ideas for an emoji?
Do they have a jury emoji?
I don't know. We'll leave it to. If not, just another law-related emoji. If you can find a jury emoji, you get 10 points. If not, just leave a regular emoji. And as I always ask people at the end of these episodes, please be kind to people when you run into them, whether you run into them at the gas station or you run into them at the grocery store or anywhere else you might run. Be nice, because, you know, you just don't know what other people are going through. And in our comments, be nice. Please, in our comments, be nice. If someone says something you don't agree with, move on. And instead of saying bad things about the commenter, because they're one of my nice viewers, whether I agree with them or not, they're giving us points, and we appreciate that. So if somebody says something you don't agree, don't disparage them. Open a new comment and tell us why you think that way. Give us some law, give us some facts. Tell us, well, I read in the New York Times that blah, 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 blah. Not that I'm recommending the New York Times, just as an example. So, yeah. All right. Thank you. Thanks, Yolie.
Thanks.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
Good afternoon, Your Honor. Robert Cosgrove from Commonwealth. Good afternoon.
Hello, Your Honor. Timothy Bederow on behalf of Aidan Kearney. To my left.
Good afternoon, Mr. Kearney.
And Mark Bederow, Mr. Kearney.
Hi, Mr. Bederow. Good afternoon. Okay, let's arraign him on the new case.
On May 13th, 2025, the grand jury sitting in the County of Norfolk returned indictment number 25 1, charging intimidation of a witness, and offense 2, charging intimidation of a witness. Do you wish to waive the full reading of these indictments?
Yes.
How do you wish to plead to each of these indictments?
Not guilty.
Thank you, sir. Is there a question of bail?
There's no question of bail, but I would ask the court to impose the same conditions that were imposed in the Stoughton District Court. And Mr. Burgess, correct me if my memory is wrong. I believe it was no contact with the alleged victim and stay 100 yards away from his place of work and residence.
What are the allegations on these, on this one?
Intimidation of a witness, Your Honor.
Yeah, but what's the nature of it?
This was the appearance outside
Outside
the shop.
Wait a minute.
Yes, correct.
Yeah, I remember. That's fine.
Judge, that's agreed under section 87.
Yeah, that's fine. All right. I'll impose that, Margaret.
Thank you.
Would you like me to do that now? Wait.
Why don't you do that now? Just do them one
Mr.
at a
Kearney, the
time.
court recognizes the person without sharing the following conditions. You are to have no contact record on record with the victim in this case. You are to stay away, have no contact, stay away 100 yards from the residence and the place of work of the complainant. Consent to those conditions, sir?
Yes.
You are hereby notified if you're charged with a crime or appeared at your release. The bail in this matter may be revoked and appointed maximum allowed to 276 section 8.
All right, what else are we gonna do?
Judge, if I may jump in right there, just for the record, we filed 2 arraignment-related motions, Your Honor.
Okay.
Obviously, we can push those to another day with 2 small exceptions of just an order to preserve notes of investigators and to preserve video, if I may, Your Honor. I don't believe there's an objection.
Okay.
There is not.
Yeah, those are both ordered. So we saw it, the Commonwealth sought it to preserve notes of investigators and to preserve video. What else can I do for you?
For me or for Mr.
Why don't I
Blair?
start with you, Mr. Cosgrove? Go right ahead.
So Your Honor entered a discovery order the last time we were here. I made substantial progress on it. I can't say I fully complied with it, but I have about, let's see, somewhere in the neighborhood of 5,000 or 6,000 pages of discovery to provide Mr. Bradel today. And I had planned, Your Honor, to file that with a motion for a protective order, which I had served on Mr. Bradel just a couple of nights from when I gave Mr. Bradel. And we have been going along with these, essentially tracking protective orders in the Karen Reed case, and in fact, much of the material is duplicative of discovery turned over in the Karen Reed case, and I pretty much follow their form protective order. These have all been allowed with the agreement of the defendant and without prejudice.
Okay.
I understand that Mr. Bradel wishes to bring that practice to an end as of today. I'm in a somewhat different position.
All right, let me hear from Mr. Bradel. Mr. Bradel,
Thank you, Your Honor.
give me your argument.
I appreciate it, Your Honor. Judge, the Karen Reed case is over with. It's moved. It's gone. Okay, and my filing, Judge, entitled Aidan Kearney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we circled back on it, but I was asking to just release everything from impoundment, Your Honor. The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not a reason to impound documents. It's actually a reason to release documents. And that's really all the Commonwealth has left on the existing stuff, is that, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad. This might, cause election shifts, and that's not a reason to impound things, Your Honor. And initially, we have sort of taken the candy from, from the Commonwealth, and when they say, just, we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point we have to get off of that train, Your Honor, you know. This is a case of immense public interest. This is a case of, you know, First Amendment issues, and I know we may disagree on that, but, you know, that's what our adversary system is for, and that's okay. And I think every case that eventually gets to the SJC or the Supreme Court starts with a trial judge maybe not agreeing with it, so that's okay. And, you know, that's what we have here. But in any event, Your Honor, I think we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in, and, you know, these text messages about, you know, and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things. So we're not asking to, you know, publish someone's address or someone's phone number. We're asking for the content of these communications that these folks have issued between and among each other, and the content of them per se has no persuasive power to make you want to impound them.
Let me ask Mr. Cosgrove, what interest at the moment does impoundment serve?
Your Honor, I've just been handed 20 minutes ago a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file a
Yeah, I'd give you that. Was a week enough?
I'd like a little more than that.
About 2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement. And if you want to file anything else, Mr. Bradle, Mr. Bederow, you absolutely have every opportunity.
Thank you very much,
Okay.
Your Honor.
Now, Your Honor, with respect to the items that I was going to turn over today,
So I'll allow the motion. Mr. Bradle, I'm up here.
Sorry, Your Honor.
Sorry.
I thought I had a minute.
That's fine. You got to talk to your client. You got to talk to Mr. Bederow. My point is this: if you want the stuff today, I'll allow it without prejudice.
Sure.
And then I'll see what you have to say and what Mr. Cosgrove.
We have to take the candy.
That's fine.
Please note our objection. Thank you.
Yeah, no, that's fine. So I will allow Mr. Cosgrove's motion without prejudice, and I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you very much.
Does that make sense? Okay.
And then, Judge, just to shift gears a little bit, there's some outstanding discovery that we've been talking about.
Yeah.
And I want to start off, I know that the court's time can be much better spent in discovery disputes. So we talked about the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out,
Yeah.
you know, I think we're going to agree to go in person with our people and figure it out. So
Yeah, sure.
that's the first thing I want to say. But then, in addition, Your Honor, there's this inventory that I filed. It's entitled Inventory of Outstanding Items in Connection with our third motion to compel.
Okay.
There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24. And second and third, you know, were the months following. And you know, in fairness, counsel for the Commonwealth was not the prosecutor of record at the time. But, you know, the rules are the rules, and we need this stuff, and it's gone on way too long. So these are the 10 things that I think are very important, maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those?
can you give me an extra week? Or?
I'll give you an extra week.
Thank you.
All right. But it is, Mr. Bradle makes a very good point. As we all know, I think that it's important that the discovery be turned over so that we can bring a timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bradle has some complaints, and some of them may well be legitimate, there has been a substantial amount of discovery
Yeah.
turned over in this case.
Yeah. If you turn it over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay,
So,
great.
Thank you. And Attorney Bederow has a number of items as well, Judge.
Mr. Bederow.
Thank you, Judge. stated under oath that they received a recording, a 30-second recording from Catherine Peter, that it was given to Lieutenant Tully and then given to Fanning, and we have no evidence of that. We don't have a copy of the recording. We were given the wrong recording in that regard. We have no police reports. We have no communications. We have nothing. If they don't exist, they don't exist, but they're obligated to look for it, make the inquiry, and report back and say whether any of this exists or not. And the last thing I'll note on that point, under the new rule, it doesn't matter whether the prosecutor credits any of this, thinks it's nonsense, thinks it might be real. They're obligated to do it, and we simply ask respectfully that the court instruct the prosecution to do that and disclose whatever evidence ought to be disclosed, or make a statement on the record that there is nothing to disclose. And if that's the case, then we'll all live and die with the consequences of that statement.
Okay, Mr. President.
No, it's largely been done.
Is that part of the 5,000 pages that you're turning over?
It is, among the things turned over is the email from Catherine Peter to Brian Tully providing that 30-second clip.
Gotcha. Okay, that's fine. So that seems to solve that. You said that you had some things you wanted to bring up. Go right ahead.
Yes, yes. So this will be an opportunity, Your Honor, for myself and Mr. Bederow to do an absolute 180 on our positions on disclosure of impounded documents. Your Honor will recall that the last time we were here, attached to a discovery motion was an affidavit.
Oh, yeah.
And at that time, it was initially filed provisionally without hearing from the Commonwealth. Was impounded upon, I believe, not the affiant's representation, but I think Mr. Bredow's representation that the affiant was in fear that there would be some sort of retaliation by the Commonwealth. I think Your Honor will recall fairly outrageous, if I can put it that way, representations that were made by the affiant. I believe now, as I moved at the time, that affidavit should either be stricken or that the impoundment order should be lifted. I don't believe an affiant should be allowed to accuse an assistant VA of jury tampering and a district attorney of having secret meetings with witnesses and all these other things, and then hide behind an impoundment order.
Okay. Let me hear from the other side. Mr. Bederow.
Yes, a couple things that I think ought to be corrected. The affiant is not alleging what happened. The affiant is alleging under oath that she was told by another individual who we were discussing earlier what happened. That's the first point. The second point is that document was attached as an exhibit to a discovery demand. Discovery demand number 4, alleging more reason to believe that there is an obligation for the prosecution to look into possible discovery that is in their possession, custody, or control. If that affidavit were to be stricken, that means literally nothing. They are still obligated to do whatever it is they had to do, and at the time that that motion was discovered until 20 minutes ago, absolutely nothing has been turned over regarding this person who brags about working for the authority. So I don't know the relevance of doing anything one way or the other with respect to the affidavit. Now, that person may very well have a privacy interest because the day after that affidavit was filed, her apartment was essentially covered in personal information about herself that could have only come from someone with access to law enforcement, and almost certainly that individual was subjected to charges of witness tampering, which I believe were actually under investigation and may still very well be. I can't go farther than that. I don't know. Somebody, whoever did this, wrote snitch on her door. So I would suggest in this situation, impoundment of her name is more
then appropriate.
Okay.
Just make 2 points in response. One, I don't think it's entirely true that the affiant was simply relying on recounting hearsay. If she was, that would say something about the credibility of the affidavit as well. But I seem to recall, Your Honor, that at this one point, the affiant represented that she was present when Ms. Peter, I believe it was having a phone conversation with Hank Brennan, and that she, the affiant, recognized Hank Brennan's voice because she was familiar with it. So I don't think it was simply a matter of hearsay. The second thing I'd say is that the identity of this person is all over the internet, and was all over the internet at the time it was before you the other day. I don't know what the interest is, given those circumstances, in concealing it in the court papers.
Judge, I'm sorry.
And I'm sorry.
I'm sorry, go ahead.
Could I just add one thing?
Yeah, go ahead.
Apparently these things that were affixed to her door in her apartment building, which is the same apartment building that Ms. Peters lives in. And I think the implication was made at the time, first of all, that event was publicized by Mr. Kearney on the internet with photographs of the door in question. And I guess I would just question, Your Honor, the source of those documents, let's put it that way.
Okay.
Very quickly, Your Honor, in terms of this individual's name being on the internet, there are 2 reasons for that. The first is because Ms. Peter identified her publicly and led to this kind of harassment. The other reason, and this was no question a mistake, but Mr. Cosgrove mentioned her name accidentally, and no question, no malintent, but her name was stated in open court, and as you can see, people watch in court, online, and whatnot. So the fact that her name had been put out accidentally, through no fault, with no malintent, is not a reason, I think, to just open up the affidavit to her name.
Okay, thank you all. So we have a date for, who was it, August? What was the date, man?
August 13th.
August 13th. And then we'll pick a date for the other issue. Am I correct, Mr. Cosgrove?
Yes,
What's the
you
end
want
of
to
the
pick
month?
it now, or do you want to pick it on the
Why don't we
13th?
pick it on the 13th? I think that makes sense.
All right, I may have some, I'm sorry, I should be stating.
That's okay.
I may have some information about
That's fine.
the health status at that time.
All right.
so.
We'll see you all on August 13th.
Thank you.
Okay, thank you all.
One more, Your Honor.
Go ahead.
I'm sorry. I believe we have an agreement. Mr. Bradle has responded relative to the source code for accessing the search of the devices. And he's indicated there was the same source code previously provided to Lieutenant Tully, and that he would supply it again if necessary. And I've indicated to him that that's appropriate, and I think he should supply it today.
Sure,
And I
Mr.
don't think
Wood.
there's a disagreement with that.
All right. You don't disagree with that, do you? All right. I'll see you August 13th.
Thank you.
All right, take care. Bye.
August 13th.